Good morning, distinguished guests, colleagues, and students. On behalf of CUHK Center for Bioethics, it is my great pleasure to welcome you all to the 8th Lanson Lecture in Bioethics. The Lanson Lecture is the annual flagship event of the Center for Bioethics, bringing together all scholars, experts, practitioners, and members of the community to reflect on important ethical issues in medicine, healthcare, and society. We are delighted to see many of you joining us today. So to begin the event, it is my honor to invite Professor Anders Ng, Acting Dean of the Faculty of Medicine, the Chinese University of Hong Kong, to deliver the welcoming remarks. Professor Ng, please.
Thank you. Dr. Zhang, Professor Falk, distinguished speaker and guests, colleagues, students, and friends. Good morning. On behalf of the Faculty of Medicine at the Chinese University of Hong Kong, it is my great pleasure and honor to welcome you to the 8th Lanson Lecture in Bioethics. At CU Medicine, we strive for excellence in education, research, and practice. Yet, true excellence in medicine is not defined by science alone. It depends also on the ethical judgment we bring to bear on difficult times and occasions, such as how to treat patients with dignity, what to do when our duties on our patients clash with utilitarian consideration, and how to resolve ethical dilemmas in practice. In this sense, bioethics is not just an add-on to medicine, it is indeed an integral part of the foundation of trustworthy healthcare system and public health. So this is precisely why the Lanson Lectures in Bioethics are so important. The series was endowed in 2016 by Dr. Edgar Zhang in loving memory of his mother, Madam Lan Yu Chen Nan Yu. Drawing upon his medical training and a deep interest in ethical inquiry, Dr. Zhang was also instrumental in founding the CUHK Center for Bioethics in 2015. And he has remained the most steadfast supporter of this center. He recognizes the questions in bioethics are inherently complex, profound, and deeply consequential, and that they require reflective, rigorous, and sustained discourse. The Lanson Lecture series was created to provide a continuing platform for exactly that kind of scholarly engagement. Over the years, the series has brought preeminent scholars in bioethics and moral philosophy to CUHK, including Professor Jonathan Gruffer, Francis Kim, Thomas Scanlon, Peter Singer, Victor Tadros, Jeff McMahon, and Bonnie Steinbock. Wow, so many names for me. So it's already the 8th lecture this time. It has fostered cross-disciplinary dialogue, linking ethical scholarship with medical practice and public policy. From end-of-life decision-making to pandemic ethics and professional accountability. Its strength lies not only in the caliber of its speakers, but also in the serious and sustained conversations it enables. We are encouraged that the Lanson Lectures have generated enduring scholarship. 5 were published as a volume by Palgrave Macmillan in 2024, and the 6th Lanson Lecture, together with the commentaries and the lectures response, will be published by Oxford University Press later this year. Today's lectures continues this tradition by addressing an urgent topic of our time, climate change. While often framed as an environmental issue, it is also very directly a matter of human health. Climate change has already caused extreme heat, flooding, drought, and disappearance of small islands due to rising sea levels, threatening the survival of humans and other species alike. So today's Lanson's lecture is therefore particularly timely. We are honored to welcome Professor Zhu Song from Seoul National University, who will be the speaker of today. We also thank the 3 commentators, Professor Martin O'Neill, Professor Lucas Stansky, and Professor Roger Zhong, our center's co-director, for deepening the discussion. My sincere thanks go to the CUHK Center for Bioethics and the organizing team for bringing us together today, and to everyone who has supported the Lanson lectures over the years. I believe this morning will be intellectually stimulating and practically meaningful, encouraging continued dialogue across disciplines and professionals. With that, it is now my pleasure to pass the stage to Dr. Enau, co-director of the CHK Center for Bioethics, for the opening remark. Thank you.
Thank you, Professor Ng, for your generous welcome. On behalf of the CHK Center for Bioethics, I extend a warm welcome to everyone joining us in person and also those in online. We are grateful to the Faculty of Medicine for its continued support. And we also wish to express our sincere gratitude to Dr. Ekerdang for his long-standing support of the center and for his vision in establishing the Lanson lectures. I would also like to send our sincere gratitude to Professor Hong Nam Lee for your continuous effort and support in arranging the excellent speakers for the Lanson lecture series as well. Today's lecture addresses the challenge that is now central to healthcare and public health ethics, climate change. Its impacts are increasingly evident in heat-related illness, changing patterns of infectious disease, displacement and loss of livelihoods, and growing pressures on food and water security. These burdens fall most heavily on those who are already disadvantaged, raising urgent bioethical questions about justice, vulnerability, and responsibility, and about what we may reasonably expect of institutions charged with protecting population health. At the same time, climate change poses a distinctive ethical difficulty. Its harms are widespread, cumulative, and often culturally opaque, emerging over time through complex interactions among many actors. This makes it difficult to attribute responsibility and to fairly distribute burdens of mitigation and adaptation. Against this background, the right to a healthy environment has gained prominence in law and climate litigation around the world. Yet important questions remain about whether such a right is conceptually well-grounded and whether it can provide practical guidance when the underlying problem is structural. In today's lecture, Professor Sriwan Song will explore these issues through the lens of the rights theory and jurisprudence. After the lecture, we will hear commentaries from our three commentators, followed by Q&A moderated by Professor Amos Tai, the Deputy Chair of Education of the CHK Department of Earth and Environmental Sciences. His works connect rigorous climate and air pollution science with agricultural sustainability. His contributions have been recognized both internationally and in Hong Kong, where he was named one of the 10 outstanding young persons in 2024. He is also the only climate scientist in Hong Kong to receive the World Meteorological Organization Research Award for Young Scientists. We're especially grateful to Professor Tai for guiding today's discussion. I'm confident that we will find today's discussion timely and also fruitful. Thank you once again for joining us.
May I now invite our three distinguished guests to join us on stage: Professor Jae-Woo Song, Professor Martin O'Neill, and Professor Amos Tai. Please join us on stage. Thank you. Please remain on stage. May I now invite Dr. Edgar Chen, Professor Hong Lan Lee, and Professor Anders Ng to come to the stage for a group photo. Thank you. Thank you very much. Please return to your seat. Thank you. May I now invite Professor Hong Lan Lee, Adjunct Professor of the Center for Bioethics, to come to the stage to introduce all speakers. Professor Lee, please.
Ladies and gentlemen, distinguished colleagues, and esteemed guests, it is my great honor to welcome you to today's Lanson lecture in bioethics on the topic of climate change. We are privileged to have with us Jae-Woo Song, Professor of Political Science and International Relations at Seoul National University. She will deliver the 8th Lanson lecture on the topic of climate change, health, and the right to a healthy environment. Professor Song is one of the most distinguished scholars in legal and political philosophy of her generation. She was born in Berlin, Germany. Her father was a diplomat of South Korea. She and her parents have therefore lived in different parts of the world, including Germany, India, Singapore, and the United States. She received her first degree in sociology from Seoul National University. Subsequently, she studied at Harvard and received both a JD and a PhD degree in philosophy. Her doctoral thesis, completed under the supervision of Tim Scanlon, is on global institutions and relations among non-co-citizens. She has been a postdoctoral fellow at the Center for Advanced Study at Goethe University in Frankfurt. She was a postdoctoral associate at the Macmillan Center for International and Area Studies at Yale. She was a visiting fellow at the School of Philosophy, ANU, Australia, and she's currently a visiting professor at the Center for Ethics at the University of Toronto. Professor Song's groundbreaking paper, Human Rights and Inequality, has appeared in the top journal, Philosophy and Public Affairs. Another important paper on universal jurisdiction was published in the Journal of Political Philosophy. Her other important publications have appeared in many Anglophone and Korean journals and books, too many to mention here. Today, we are fortunate to have her deliver the 8th Lanson lecture in bioethics. I shall now introduce the commentators. Our first commentator is Professor Roger Zhong, co-director of the CHK Center for Bioethics. Having graduated from Johns Hopkins with bachelor and master's degree in public health, he studied for a PhD in social epidemiology at the University of Hong Kong. He also received a master in bioethics at Harvard Medical School. He is associate professor at the School of Public Health and Primary Care at CHK. His current research investigates social determinants of health, such as poverty, deprivation, socioeconomic disadvantage, environmental and housing factors, and migrant status. He is also particularly interested in the health of vulnerable populations, including migrant workers and rare disease patients, and conduct research on aging-related issues such as multimorbidity and long-term or end-of-life care. He has published some 120 peer-reviewed publications. Some of these have appeared in the Lancet, BMJ, and the American Journal of Bioethics. Our second commentator is Martin O'Neill. Professor O'Neill is professor of political philosophy at the University of York. He is an elected fellow of the Academy for Social Sciences. He was educated at Oxford and then Harvard. At Harvard, he completed a PhD degree in philosophy under the supervision of Tim Scanlon and Derek Parfit. Before coming to teach in York, Professor O'Neill had been a research fellow at St. John's College, Cambridge, and also at other universities. He is the author of numerous articles, as well as the co-author of 3 books. His articles have appeared in leading journals of political philosophy, including Philosophy and Public Affairs, Journal of Political Philosophy, Journal of Social Philosophy, and many others. His publications have been translated into 6 languages, including Chinese. Some of his work has been discussed in The Economist, The Guardians, and other venues. Our third and final commentator is Lucas Stancic. Professor Stancic is Associate Professor of Philosophy at Harvard. He worked on topics at the intersection of political philosophy and political economy, including various issues of economic justice, liberal rights, and constitutionalism, the ethics of climate change, the philosophy of economics, and the moral significance of inequality. His publications have appeared in Philosophy and Public Affairs and other leading journals. Before joining the philosophy department at Harvard, he was assistant professor of political science at MIT, and he has held visiting fellowship at Brown and Princeton. He completed his PhD in political science at Harvard and studied law, literature, and political theory at McGill. Without further ado, let's welcome Professor Song to deliver her Lanson lecture on the topic of climate change, health, and the right to a healthy environment. Thank you.
So, thank you for the kind introduction and the generous invitation to speak to you. My topic today is noted. Oh, thank you. Climate change and how the world is responding to it. I'll eventually zoom into a specific kind of response to climate change that's becoming quite popular around the world and that I happen to know something about as an academic, namely the strategy of arguing that climate change threatens a specific basic or human right, or what's called the right to a healthy environment. But first, I want to run through some general facts about climate change and health, which should remind us of the importance of our topic today. Perhaps we don't need too much of a reminder since it's now widely documented and accepted that climate change has serious negative impacts on health. These impacts have been documented, for example, by the medical journal Lancet, which has been publishing what's called the Lancet Countdown on Health and Climate Change since 2017, which is an annual indicator report authored by several dozen academics around the world. The most recent report from 2025 warns, among other things, that the multiple impacts of climate change are converging to create an unprecedented threat to the health and survival of people around the world. So here are just some figures to drive the point home. Deaths from heat waves increased 23% since the 1990s from this to this. Compared to the period of 1980 to 2010, by 2024, 123.7 million more people were experiencing moderate to severe food insecurity from droughts and heat waves. In 2024, an estimated 154,000 people died from wildfire smoke-derived pollution. There are many more examples showing similar patterns. In general, extreme weather events, precipitation, wildfires, drought, pollution, etc., have become more drastic and more frequent, leading to deaths, health deterioration, food insecurity, displacement, and other problems. Among the other problems is that climate change creates favorable conditions for deadly infectious diseases that some people in this room probably know much more about than I do. For example, dengue, malaria, West Nile virus, leishmaniasis, tick-borne diseases, fibrosis, and so forth. Climate change also has what we might call indirect negative effects on health by eroding socioeconomic conditions. For example, according to the Lancet report, heat exposure led to decreases in global labor capacity amounting to the equivalent of over $1 trillion in income loss in 2024. More generally, extreme weather caused the equivalent of $304 billion in global economic loss. And even further down the line, climate change can make worse what scholars call the drivers of social conflict, things like poverty, weak governance, socioeconomic inequality, and so forth. And these negative impacts further are disproportionate in troubling ways. So they impact people who are already vulnerable even more severely, which is a problem among other reasons because these people are also the least well prepared to deal with the negative impacts of climate change. To take just one small everyday example, this is a graph showing the percentage of, let's see, the percentage of households with air conditioning, the changes in that percentage from 2000 to 2023 by countries. As you can see, countries higher on the Human Development Index, or HDI, show a clear increase in percentage of households with AC. Whereas for countries with low HDI, the percentage remains low, begins and remains low, right? So to sum up then, climate change threatens health both directly and indirectly by weakening and destabilizing what the report calls the social, political, cultural, and economic conditions on which health depends. Now, I believe that Professor Roger Chung will speak to this fact in more detail in his comments, and I look forward to discussing that with him. For now, though, let's turn to the question, given these troubling facts, what is the world doing about climate change? Now, on a global scale, the response has been strikingly inadequate. So as you can see here, the temperature target set by the Paris Agreement, which is the currently controlling international climate treaty, is that we'll try to stay no higher than 1.5 degrees Celsius above pre-industrial levels. The dark blue box here is the estimate of where we'll end up if we continue as we've been doing now. So we'll be way past the goal and likely reach catastrophic levels. Even on the most optimistic scenario, we're probably going to fail in meeting this goal. And we're not very much near meeting the optimistic scenario. The optimistic scenario itself is quite optimistic. And one troubling fact here, also noted by the Lanson report, is that responses to climate change at the state level have been weakening. Not all states are like this. Some states have been acting aggressively, for instance, to introduce renewable energy. So they've been doing quite well. But a lot of states, in many states, what's been aggressive instead has been things like fossil fuel subsidies. And governmental engagement with climate change and health has been decreasing. And there's also been quite a bit of political climate backlash and associated political failures led, for instance, by the emergence of climate skeptical political parties. So against this backdrop, individuals and independent organizations have been seeking various alternatives. So against the backdrop of there being climate backlash and various political challenges at the state level, the alternative that I want to focus on today, which is also noted in the most recent Lancet report, is the strategy of climate litigation that is going to courts to get courts to tell various actors, governments, corporations, et cetera, to do more about climate change. This is how the report understands the strategy, and I'm quoting here. The rise of climate skeptical political parties in many high-emitting countries means that the courts will undoubtedly be a crucial arena for individuals and independent organizations to hold governments and corporations accountable and advance health-protecting climate change action. That is, we can expect more of this in the future. It's already gaining traction. We can expect more of it. Now, a large part of climate litigation is rights-based litigation. So when someone brings a case of rights-based climate litigation, the argument generally has this form. First, there's the claim that climate change threatens some basic right. So a human right under international law or a right guaranteed in the constitution of the country in question. The second claim is that the government in question has an obligation to protect this right. So when the government fails to do enough to address climate change, it violates its obligation to protect the right in question. Now, over the past several years, there's been a huge burst of court cases around the world brought under precisely this logic. And one advantage of this approach, sometimes called the rights-based approach, is it allows us to focus on the plight of individuals rather than aggregating across them, as we would with, say, an economic cost-benefit analysis of the use of renewable energies, of mitigation measures, and et cetera. And since, as we saw, climate change affects vulnerable persons more severely, this disaggregated approach may serve useful in various contexts. And I think I will have occasion to return to this point in response to Professor Stanczyk's comments, but we'll see. For now, I want to move on to the question of which particular right then is going to be invoked. And this depends on things like matters of strategy, what kinds of law are in place in the particular country where the case is being brought. Today, I want to zoom in on one very popular right that is being used these days, namely what's called the right to a healthy environment. This right is found in the national laws of over 100 countries around the world. Some people call it the most popular new constitutional right in the last 50 years. It's found in some regional human rights systems, such as the Inter-American system and the African system, which indicates further traction around the world. It's less relevant for those of us in Asia because Asia doesn't have a regional human rights system. But I just mentioned these examples to show that around the world, this right is becoming quite popular. Another indication of its popularity is the fact that the right is being used widely in rights-based climate litigation. For example, in my own country, South Korea, this right is in the constitution. And there was a very high-level case in 2024 at the Constitutional Court of Korea, where the court found that Korea's climate laws were partly in violation of the right to a healthy environment of future generations because its long-term mitigation goals were too vague and amorphous, were not specific enough. Right? Now, interestingly, though, the right to a healthy environment is not yet a part of international law. Right? There's no legally binding treaty that includes this right. There are, though, signs that we might be moving in that direction. In 2023, the United Nations General Assembly adopted a resolution affirming an international human right to a healthy environment. And what this means is it's not the case that a General Assembly resolution creates law, but it is a kind of a compelling, significant political statement that that's where the law should be going. And last year, the International Court of Justice, which is a highly authoritative court, issued an advisory opinion on climate change where it recognized the importance of the human right to a healthy environment. And I'll return to what the court said more specifically later on. For now, though, I want to note that for an international legal theorist like me, these developments are all quite interesting. So the theoretical idea of this right to a healthy environment, which first gained attention in the 1970s, began as an idea within international human rights. From the outset, it was met with a lot of suspicion and skepticism by both academics and lawyers. So those of us who are in international human rights thought that this right was a kind of an ideal, an ambitious idea that was being floated around. We weren't sure that it was going to go anywhere. But then, for some reason, in the meantime, all of these national constitutions began adopting the right within domestic jurisdictions. So that creates the question, or that invites the question, should we revisit the theoretical justification for the human right to a healthy environment? That is, can this right coherently fit into our best theories of human rights? And this is the question that I hope to answer today. And in doing so, I hope also to respond to the two objections to the right to a healthy environment that seem to me to be the most persistent in the literature. The first is what I'll call the redundancy objection. This is the thought that whatever interests the right to a healthy environment may protect, these interests are already protected by well-established rights, such as the right to life or the right to health. So recognizing the right to a healthy environment would be redundant, it would be unnecessary. That's one objection. The second objection is what I'll call the fittingness objection. This is the objection that because of the way that international human rights laws and institutions are set up, a healthy environment is not the kind of thing for which there could be meaningful obligations. This is because the law is set up such that each state is responsible for the human rights of persons within the state's jurisdiction. So its citizens or those living in its territory. Yes, of course, human rights are international, but what we mean by that is if another state isn't protecting the rights of its citizens, persons within its territory will monitor that and try to get that state in line. But environmental degradation is transnational, right? So there's only so much that each state can do to solve the problem. So there's a problem of fit here, is the objection. Now, I'll respond to these objections by first putting forth a positive argument for a human right to a healthy environment. Specifically, I'll argue that if we adopt one influential understanding or conception of what human rights are, then we end up with an argument for a human right to a healthy environment. So on this conception that I'll work with, human rights are institutional protections of urgent human interests against predictable dangers in our world now that are matters of international concern. So there are four components to something being a human right. This statement most closely tracks the views of the political philosopher Charles Bates, Henry Shue, James Nichol, Tim Scanlon, the last of whom was a previous lecturer of this forum, has already been mentioned a couple times in the introductions. These are other influential philosophers whose views on rights are in this vein. So here's a visual representation of what I just said, which admittedly was a mouthful. So human rights are what fall into the innermost purple circle here, where all four of these components are met. All four of these components are met. So to be a human right, it's not enough that some urgent human interest is at stake. For example, I think, we may all have an interest in listening to beautiful music, right? This is an interest that is not, as far as I can tell, facing predictable dangers in the present world. If anything, we're living in a world where it's becoming easier and easier to listen to beautiful music with things like online performances and streaming services, right? Next, even if some urgent human interest exists and is facing predictable dangers, it may be the case that there aren't effective institutional protections that are feasible and appropriate. So consider something like equality of educational opportunity. We may have an important interest in this. It may be that we live in a world where this equality is very easily undermined, is facing predictable dangers. And there may be some institutional protections that we can afford to this problem. But there's one persistent undermining factor, which is the fact of the family. Right? So parents pass on educational advantages to their children just by being who they are, doing routine things like having conversations with their children, reading books to them. And because parents are different levels of educational advantage are passed along, and the equality keeps getting undermined. But it seems strikingly dystopian to think that we would try, say, through government regulations, to interfere in family activities to equalize all of that, right? So this is the third level is another important kind of barrier that we have to pass in order to get to this innermost circle. And the last level is that when we say that something is a human right, we mean that it's appropriately a matter of international concern. And this is what distinguishes a human right from other kinds of basic right, for example, a right that's in the constitution of one single country. So I want now to try fleshing out these thoughts for the right to a healthy environment to see if we can land in this innermost circle for the right to a healthy environment. So first, there's the question of what kind of urgent human interest might be at stake. And I think one way to understand the interest is that we have an urgent human interest in the natural environmental conditions for adequate human functioning, understood to include various valuable socioeconomic, political, and cultural activities in which humans engage, and for which some reasonably tolerable set of conditions for embodied existence is required. So this is a very broad gloss. I think it's made appropriate by the all-encompassing effects of climate change. We could alternatively, I'm not in suggesting this broad gloss excluding the alternative of working with something narrower, like just the interest in life or in health or well-being, right? I think the fact that we can describe urgent human interests in these various different ways shows that this first step of the argument is not that difficult to satisfy. We should note, though, that to be persuasive, the interest at this stage needs to be understood as demanding adequate rather than maximal human functioning. To demand a right to have a right to think that we have a right to maximal human functioning that creates claims on government seems to be a bit too much. And it's the same with most human rights, right? The level is usually, the standard is usually a standard of adequacy, right? So next, we move on to the stage of predictable dangers. I feel like this stage is also rather uncontroversial. That is, it seems uncontroversial that absent institutional protections, such as laws of environmental regulation, enough actors, maybe not everybody, but enough actors will tend to act in ways that degrade the natural environment, such that worries about erosion of the conditions for adequate human functioning arise. The clearest and most devastating example of this might be climate change, but familiar examples with, say, air and water pollution abound. Right? So that was the second stage. So what of the next stage, that is of institutional protections? We know from examples of most advanced economies in the world now that environmental regulation is both feasible and appropriate, right? So most advanced economies in the world now have some regime of environmental regulation in place. Even if implementation is often imperfect, sometimes we see dramatic failures, we do see something that is feasible and appropriate in the sense of operative, right? If not perfectly realized. And then finally, we move to the stage of establishing feasible and appropriate, effective international concern. Right? Now, on the point of feasibility, I feel like we see examples of operative international treaties regulating various kinds of environmental conduct. For example, conduct at sea, conduct affecting endangered wildlife, conduct concerning hazardous waste. There are treaties on all of these subject matters. Not all of them are very well known, but they exist and are operative, right? Even if, again, implementation is imperfect, some of these treaties, very important states are not parties to the treaties, so there is imperfection here, but still they're up and running. Now, on appropriateness, with cases of environmental degradation, international concern will often be appropriate simply because it's necessary, right? Environmental degradation has transnational effects, so effective response will require international cooperation. And climate change, again, is an especially clear, perspicuous example. So that's a sketch of a positive argument for a human right to a healthy environment. There's a lot to discuss by way of details, and I believe all three of my discussants today will press me on them. For now, though, I want to return with the sketch in hand to the objections to the right to healthy environment that I described earlier. And let's begin with the redundancy objection. This is the objection, recall, that we already have rights expressing the same underlying interests that a right to a healthy environment would protect, right? So adding this further right would just amount to unnecessary, unmotivated rights inflation. More specifically, someone who holds this objection might say something like, okay, look, take whatever kind of human functioning we think is important, or whatever precondition for human functioning that we think is important. There's already going to be a well-established human right protecting that. The right to health, right to life, right to adequate standard of living, to education, privacy, and family life. There's even something in international law called the right to take part in cultural life and scientific progress, right? So the idea is we already have a whole bunch of rights that would be protecting the same interests. Now, I think the response to this objection is simply that, yeah, that may be the case, but that's the case for all other rights as well. That is, many rights overlap in the interests that they protect. And this overlap doesn't by itself give us reason to disqualify something from recognition as a right. So for instance, on many accounts of human rights, the rights to freedom of expression, to freedom of religion will overlap in protecting interests in forming and expressing one's own beliefs and values. The right to education, to social security will overlap in protecting interests in self-realization, and so forth. Now, we might ask then, okay, if that's the case, why is that the case? Why should we allow for so much overlap among rights and the interests protected? One compelling reason is that there are distinct patterns of predictable danger or threats to the interests at stake, as well as distinct kinds of institutional protection that seem feasible and appropriate. So if you recall the 4 circles, the outermost layer may admit of a lot of overlap, but the inner layers will differ, right? So educational opportunities are threatened in distinct patterns and best protected by laws on education, same for Social Security, and so forth. The right to a healthy environment, as we saw from the arguments so far, responds to a predictable pattern of human behavior resulting in environmental degradation, which is a distinct pattern not clearly addressed by any existing right. The requisite institutional protection, national and international regimes of environmental regulation also marks out a distinct type of institutional right that's not already established through other rights. So we have support for this view from the International Court of Justice's opinion on climate change, which I mentioned earlier. In the opinion, the court said, and I'm quoting here, and I reproduced the quote here on the slide, "Insofar as states parties to human rights treaties are required to guarantee the effective enjoyment of these treaty rights, it's difficult to see how these obligations can be fulfilled without at the same time ensuring the protection of the right to a clean, healthy, and sustainable environment as human right." So that's just the formal name for what I've been calling the right to a healthy environment. So the idea here is that the layer of institutional protection that would be demanded by the right to a healthy environment, or the set of obligations attaching to that right, is distinct from what states are obligated to do for other rights, and moreover, seemingly necessary for states to fulfill these other obligations. And so that's the response, I think, to the redundancy objection. So let's turn next to the fittingness objection. And this is the objection recall. It says, human rights treaties call for state obligations towards citizens or people in state territory. But what can one state do about transnational environmental degradation, like climate change? Not much. So it doesn't seem to make sense to try to fit environmental protection into human rights. We're working with the wrong category here, is the objection. Now, in the literature, there are 2 versions of this objection, which are not always clearly distinguished, although I think they should be. I think the kind of conflation here might be, and this is just armchair conjecture, might be a function of the fact that oftentimes this objection is raised by lawyers. But so the 2 versions, of the 2 versions, there's a legal version, which is just that this is what the law says, right? The law says that obligations are just to citizens, state obligations are just to citizens or people within their territory. Now, legally, and this is a legal argument, so the philosophers in here might just have to trust me on this. But legally, this is not entirely true, right? So this state to citizen or state over its territory case is, to be sure, a common and perhaps the default case in many international human rights treaties. But many treaties also say something else, that states also have obligations of international cooperation to realize treaty rights generally. And where the treaties don't explicitly say this, courts, especially recently, have been interpreting in individual cases the law to require transnational or extraterritorial action in maybe not all cases, but oops. Sorry, got too excited talking about the law. Courts, maybe not in all cases, but in a number of notable recent cases, have been interpreting the law to include this sort of extraterritorial international dimension. So the point to note here is that the law is in flux. It's changing, which is to say the more pertinent question for us is not what the law is, because that's kind of a confusing question, but rather what the law should be in this situation of flux, which brings us to the normative version of the argument, which is that this is how international law should be. Now, there are ways of expressing the thought in a more sophisticated way. I mentioned earlier that I'd be drawing on Charles Beitz's theory of human rights. Beitz proposes what he calls a 2-level model. So on this model, states have primary responsibilities for the human rights protection of those within their jurisdiction. And outside actors, other states, individuals, intergovernmental organizations, and so forth, have secondary responsibilities. On one way of specifying the model, we might say that the primary responsibility is that of protection, and the secondary responsibilities are largely just to monitor what other states are doing, right? And to hold the primary responsibility bearer accountable when it fails too seriously, right? So say Brazil, that's a prominent country here. Brazil has primary responsibilities for the human rights protections of people who are in Brazil, and Brazilian nationals. Australia, with respect to whatever's going on with Brazilian nationals, only has the responsibility of checking in from time to time whether Brazil is doing its job as a primary responsibility bearer. And that's the extent of it, right? That's all we mean when we say that human rights are matters of international concern. So that's the sort of fittingness objection that's normative of register. Now, I do think there are good reasons to make each state the primary responsibility bearer for human rights within its jurisdiction. This is a kind of an effective division of labor, right? Much easier for Brazil to be responsible for the human rights of people in Brazil than, say, the Australian government to try to do that, right? It also helps to respect the sovereignty of each state. But it would be a mistake, I think, to think that secondary responsibilities are exhausted by monitoring and some kind of accountability. Instead, we can imagine relations of cooperation where each state is responsible for contributing to an internationally coordinated effort to ensure effective human rights protection around the world. And I'll try to say some things to flesh that out. So one reason that it may seem natural to take the more restrictive view of secondary responsibilities as just about monitoring is perhaps the empirical dimension of human rights. So recall I said that human rights are institutional protections against predictable dangers in our world now. That means that human rights will be shaped by empirical facts about the world now, what counts as predictable dangers in the world as we're living in it. Historically, when the human rights system was first being set up after World War II, it was a response to what Beitz calls the pathologies of a global political structure consisting of states not subject to higher order control. Pathologies here is, of course, a metaphor, a medical metaphor, no less. The thought was that we have this international system consisting of states that enjoy broad discretion about what's going on in their own states. And this is a good thing for many reasons, but it comes with risks, certain pathologies. In the earlier part of the 20th century, the international community realized that some states, when left to their own devices, could do things like commit genocide, right? Systematize discrimination, right? Set up a system of apartheid, for example, neglect important material needs, and etc. And these were deemed to be human rights violations, and the international human rights system was set up as a response. Now, the important thing to note here is that these specific 20th century examples are just that, examples of pathologies of the state system at the time. As long as human rights law and institutions are guided by the more abstract goal of responding to the pathologies of the state system, there's no reason to think that human rights should be time-stamped to the 20th century and the level of moral progress that the international community had made by then. Instead, being appropriately guided by the goal of protecting against the pathologies of the state system requires being open to the possibility that new pathologies may arise, or alternatively, we may newly discover pathologies that were always there, but we didn't really quite realize were pathologies. So here's one example. Let's call structural threats, widespread, typically transnational, systemic phenomena, that have obvious negative impacts on the urgent human interests that human rights are meant to protect, but where the causal connections between specific impacts and particular actors are not obvious. So there is a causal opacity there. Transnational environmental degradation like climate change is a clear example of a structural threat. This is how climate change seems to work, but there may be other examples too: poverty, epidemics, economic inequality, and so forth. Now, structural threats create an occasion to evolve the international human rights practice in a principled way. Structural threats like climate change present a class of predictable dangers to the urgent human interests that human rights were designed to protect. But the state-based international system is currently not optimally set up to address these threats. We would need to evolve the system to develop more sophisticated, more robust frameworks for cooperation. In human rights law, we would need to, in many cases, to allow for human rights claims to be brought, even when causal connections between act and negative human rights impact are opaque, as they typically are with structural threats. The normative version of the fittingness objection says that we shouldn't go in this direction. It seems ad hoc, what's going on. But on the view that I'm proposing here, such evolution is not ad hoc, but rather principled. It's faithful to the point of having human rights law and institutions in the first place, which is to protect against whatever pathologies of the state system we discover. Question then is, can structural threats be accommodated in the necessary ways? I want to propose a kind of a measured optimism here, at least in the case of environmental threats like climate change, based on our earlier assessment that institutional protections in this area are feasible and appropriate. We see this happening all the time. Lots of countries have fairly detailed operative regimes of environmental regulation going on. And international concern is also feasible and necessary. We have international treaties on environmental issues. We have a climate treaty that's sort of working. That's why I say measured optimism. But the thought is the opening is there. The opening is there to make the right kind of evolution. Where secondary responsibilities are not just of oversight or monitoring, but also of cooperation through things like international environmental treaties. Now, I believe some of my discussants will probe these points, but we can discuss them later. For now, I want to go into a bit more detail about how all of this fits with the right to a healthy environment. So it seems to me that we can see the right as one part of a response to environmental structural threats like climate change. The right and the obligations that it generates calls for international regulation to address transnational environmental degradation and compliance with such regulation, such as the UN Climate Treaty Framework, including the Paris Agreement. Now, one encouraging sign that I see, and I know some of my commentators, my discussants will press me on this, but one encouraging sign that I see here is that there have been a number of court cases around the world affirming the right to a healthy environment that in doing so presuppose clear state obligations to comply with the Paris Agreement, at least where the state in question is a party to the agreement. Not all states are party to the agreement, but many states are parties to the agreement. So what happens in these court cases is the court, in deliberating over whether the right to a healthy environment has been violated, simply assumes, without contesting, that the government has clear obligations under the Paris Agreement to take steps of climate mitigation, right? That's not in question. So international cooperation through international regulation is contemplated as a default in these decisions, which I feel signals the feasibility of evolved human rights norms to accommodate environmental structural threats by introducing robust obligations of international cooperation. To sum up then, the right to a healthy environment, if everything I've argued is on track, is justifiable as institutional protections of urgent human interests in the natural environmental conditions of adequate human functioning against the predictable dangers of transnational environmental degradation. And these are matters of international concern because the threats are transnational and the solution must be international and take some form of international cooperation. So that's the philosophical argument that I've sort of dosed with some reasons of measured optimism. Having done that, I want to temper the discussion so far a bit further by taking stock in what I've just done. So again, what I've given is a philosophical argument for the right to a healthy environment and a defense against what I take to be the most persistent philosophical objections, namely the redundancy objection and the fittingness objection. I haven't argued that pushing for the international recognition of a human right to a healthy environment or using it in national climate litigation, as many climate advocates have been doing, is strategically an optimal way to respond to the current climate emergency. This is a separate empirical question, it seems to me. For instance, we would want to monitor in longer terms, timeframes, what happens after a court rules that a country's climate laws are in violation of its constitutional right to a healthy environment. What kinds of measures are taken on after that? And do they actually make a positive difference? That's the kind of empirical information that we want to keep track of to answer this question. Is this a strategically useful thing to do? And this is a question that's not my area of expertise. I'm not going to investigate it myself, but I am deeply curious about what the answer is. But so that's my talk. Thank you, and I look forward to discussion.
Thank you, Professor Song, for that inspiring lecture. So we will now move on to the commentary session. As introduced, we are pleased to have three distinguished commentators with us today. May I first invite Professor Roger Chong to come to the stage to share his comments. Professor Chong, please.
Thank you to our distinguished speaker, Professor Song, for the very rich and thought-provoking Lanson lecture. I'm very honored to be here today to be serving as a discussant. So thank you, Han, for inviting. For my response, I feel like I'm not really pressing Professor Song here, but it's more like, I feel like I'm in an echo chamber here. But I will mainly build on Professor Song's argument with some additional considerations from the public health and also global health justice perspectives. Specifically, I want to build on it in two ways. First, by connecting it more explicitly to the concept of social determinants of health, a framework that I believe strengthens the case of why environmental conditions matter. And second, by addressing the scope of global health justice, arguing that even on a statist interpretation of justice, climate change itself provides the empirical evidence of transnational interdependence that statists have always required. So first, the social determinants of health. This concept, central to contemporary public health, refers to the conditions in which people are born, grow, live, work, and age. These include, as you can see here in this framework, education, employment, income, housing, food security, governance and policies, and critically, the physical environment. Now, what the social determinants of health framework highlights for us is that health is not primarily produced in clinics or in hospitals. It is produced in neighborhoods, workplaces, and our ecosystems. When the Lanson Countdown report documents how climate change affects water and food security, sanitation, cardiovascular and respiratory diseases, mental health and labor capacity, it is documenting disruptions to the very foundations of population health. So here's why this matters to the right to a healthy environment. If health is affected by social determinants, and if environmental conditions are among the most fundamental of these social determinants, then the right to health itself may be impossible to realize without also ensuring a healthy environment. I think this is precisely the point the International Court of Justice made in its 2025 opinion that states cannot fulfill their obligations to protect human life and well-being without protecting the environment. However, this line of argument raises an important question that I want to address directly now. I got this question a lot, when I'm lecturing for public health students and medical students. If health is shaped by so many factors, genetic, behavioral, social, environmental, and even sometimes pure luck, right? How can we meaningfully speak of a right to health at all? And if the right to health itself faces this challenge, doesn't the right to a healthy environment also simply inherit the same problem? Now, this is a concern that scholars and practitioners have been grappling with extensively, and I think their responses are instructive for our discussion here today. So I'd like to bring them together. First, international human rights laws have developed the concept of progressive realization. Found in Article 2.1 of the International Covenant on Economic, Social, and Cultural Rights, this principle acknowledges that rights like health cannot be realized overnight or fully controlled by any single actor. Instead, states have an obligation to take deliberate, concrete, and targeted steps toward full realization using the maximum of available resources. The key insight here is that rights require states to move in the right direction instead of guaranteeing perfect outcomes. In other words, we can hold states accountable for failing to take reasonable steps, even if we cannot hold them accountable for every instance of illness. Second, we must distinguish between the right itself and the outcome it tries to protect. The right to health does not promise that everyone will be healthy, and that would be impossible, and I would think it would even make a mockery of the rights language. Rather, it promises access to the means to health, like healthcare, safe food and water, sanitation, education, and yes, a healthy environment. The right is violated when states fail to provide these means, not when individuals inevitably fall ill from causes beyond anyone's control. So this distinction is crucial, for it tells us that what we can reasonably demand of our duty bearers. And third, human rights law employs what they call a tripartite typology of obligation: to respect, to protect, and to fulfill. States must respect rights by not directly violating them, for example, by not deliberately polluting our air. They must protect rights by preventing third parties from violating them, for example, by regulating industrial emissions. And they must fulfill rights by taking positive steps to enable their realization, like by building healthcare infrastructure or establishing environmental monitoring systems. And last, many theorists argue for a minimum core approach. That is, identifying essential levels of each right that must be immediately guaranteed regardless of resources. The idea here is to focus on the most severe deprivations that are clearly within state control, while acknowledging that full realization remains an aspirational goal. So what does all these mean for the right to a healthy environment? I think that they mean that complexity and multi-causality are not disqualifying, as Professor Song also alluded to. The fact that environmental factors are not the only determinants of health does not mean that they're not remediable or actionable. The right to health has faced these similar challenges, and the human rights practice has developed these tools that I've introduced just now to address them. So the right to a healthy environment can also draw on these same tools. Now, let me push this point a little bit further. The social determinants of health framework reveals that environmental degradation doesn't just incrementally damage health. It restructures the conditions under which health is possible. When climate change increases the transmission of infectious diseases, it doesn't merely add one more risk factor to an existing list. It transforms the epidemiological landscape. When heat waves threaten food security and nutrition, they don't simply reduce calories intake. They reconfigure the entire food systems. So the right to a healthy environment, I think, is not redundant with the right to health. It protects something distinct. That is, the ecological conditions that makes population health sustainable over time. Even if every individual had access to health care, they would still be vulnerable to the health impacts of a destabilized climate system. In other words, it goes beyond healthcare, and we need to go beyond healthcare. Now, that brings me to my second point today, the scope of global health justice. And this gets a little bit more interesting, probably. Now, we need to talk about justice because justice pertains to the system or principle that ensures rights of any individual are respected and balanced in our society. Professor Song today has already addressed the fittingness objection, arguing that international human rights practice can and should evolve to address transboundary threats. And I want to approach this from a different angle through the debate between statists and cosmopolitan conceptions of justice. All right, these two. Now, let me briefly sketch the two positions regarding the scope of our obligations across borders. Statism, okay, or liberal statism, is the view that principles of justice apply primarily within the boundaries of sovereign states. On this view, our strongest obligations of justice are to our fellow citizens with whom we share a common political framework, legal system, and set of social institutions. And obligations to those outside our borders are typically much weaker and not prioritized. This position is very famously associated with political philosophers or the work, although they may not call themselves statists themselves, like John Rawls, and also has been developed in the health context by Norman Daniels, as well as others like Thomas Nagel. On the other hand, cosmopolitanism holds that principles of justice, that's on the other side, okay, apply to all humans equally, regardless of national citizenship. Cosmopolitans argue that the moral worth of persons doesn't diminish at borders. If inequality matters within a society, it matters globally. Our obligations of justice extend to all, constrained only by the feasibility of institutional arrangements. Now, it's important to recognize that statism is not a monolith. There's some nuance here. For example, Norman Daniels urged us to resist the pull of the cosmopolitan intuition, not because he is indifferent to global health, but because he worried that weakening national health systems as the primary institutions through which health is actually delivered would undermine the very foundations of health justice. But at the same time, Norman Daniels explicitly distanced himself from more extreme forms of statism that could exonerate states from all responsibility for the consequence of their behavior beyond their immediate borders due to the absence of a global state. So even within the statist camp, there is room for debate about what we owe to our non-citizens and under what conditions. Now, with that nuance in mind, I want to take seriously how statist arguments might apply to global health and climate change. Statists may argue, even if we care about the health of those in other countries that are affected by climate change, this remains more of a matter of humanitarian assistance or international charity, something that is not prioritized as a matter of justice. Now, one of the reasons is that, they say, the current global order does not represent a form of relational interdependency that resembles the conditions of social cooperation and economic institutionalism found within states. The current global order, they may argue, does not feature basic institutional conditions analogous to those under which Rawls would argue justice should and can apply. Trade agreements, diplomatic relations, international organizations only create thin threads of connection, but not really the thick fabric of a shared basic structure. Now, some people may dismiss this line of thinking by pointing to the US recent withdrawal from the Paris Agreement, justify in the name of national sovereignty and domestic interests. And then they will say, see, I told you so, right? But that would be like attacking a political straw man rather than engaging the philosophical position on his own terms. The more interesting and productive question I think that we should ask is whether statism inevitably leads to that conclusion, to withdraw from Paris Agreement, for example. And I would like to suggest that it doesn't, okay? That statism does not inherently oppose global action on climate change. Now let's consider what status require for justice to apply. For Rawls, principles of justice govern what he calls the basic structure of society, right? Which includes the political constitution, property regimes, economic organization, and family units. What makes these institutions subject to justice is that they exercise profound and pervasive influence over individuals' life prospect ever since birth, right? They shape expectations and opportunities and outcomes in ways that are neither chosen nor easily escaped. Now, the meaningful question we should therefore ask is, does climate change create anything like a global basic structure? Now, I want to suggest that it does in three ways. Number one, climate change creates a global system of burden and benefits distribution that operates with the same pervasiveness as domestic institutions. Here's some example. When a factory emits carbon in India or China, okay, it contributes to a stock of greenhouse gases that raises temperatures globally. The benefit, the economic output, the jobs and the products accrues locally, but the burden, like the heat-related mortality, infectious diseases, spread, crop failure, all these is distributed across the planet, often falling most heavily on those who contributed minimally to the emissions. So this is not a thin transactional space here. This is a systematic mechanism for transferring costs from emitters to non-emitters, from present to future, and also from the powerful to the vulnerable. And second, the system inescapable in precisely the way domestic institutions are. One cannot opt out of our global climate system. The teenager in Bangladesh whose village floods and the farmer in the African Sahel whose crops fail and the older persons in Europe who dies during a heat wave, none of them chose voluntarily to participate in the system of burden distribution. And third, there's now this emerging institutional architecture that explicitly recognizes all these interdependence like the Paris Agreement, the UN framework, IPCC, etc. They are, I would say, rudimentary, imperfectly enforced probably, but they represent exactly the kind of institutionalized cooperation that statists have always pointed to as a domain of justice. So today I'm making an empirically grounded claim here that climate change specifically creates the kind of relational interdependence that statists have always said would trigger justice concerns. And this is, I think, great news, because what this is saying is that the apparent disagreement between statists and cosmopolitans on climate change may not really be a morally fundamental one. To use the language of Mark Timmons, statists and cosmopolitans may on the surface disagree with the scope of justice and global health, but when we get the empirical facts straight, there is room for convergence. Now, I'm almost concluding. I want to sound just a few caution from a public health perspective, not to undermine the right itself, but to ensure that we approach it with clear eyes. It is that rights are powerful tools, but they are not magic, right? Nor are they the only thing that matters morally. The right to health itself has been constitutionalized in many countries, yet health inequities persist, and in many cases worsen. We must therefore be attentive to what public health researchers call the implementation gap. We must remember that health is produced not only by rights, but by resources. A right to a healthy environment means very little without institutional capacity to make it real. And the legal frameworks are necessary, but insufficient, I would say. They require vigilant monitoring, political will, and civil society engagement. A community that pours all its energy into litigation while neglecting grassroots organizing or policy advocacy may find itself with a favorable judgment, but no political infrastructure to enforce it. To conclude, the climate crisis is a crisis of health equity. if we properly understand it and implement it, the right to a healthy environment can be part of the infrastructure we need to protect the conditions on which health depends. Professor Song today has given us philosophical reasons for optimism. The work turning that optimism into reality remains before us. Thank you very much.
Thank you, Professor Chong. May I now invite our second commentator, Professor Martin O'Neill, to the stage to share his comments. Professor O'Neill, please.
Wonderful. So it's a real honor to be here on my very first proper visit to Hong Kong. I've only ever changed planes here in the past, which isn't really a proper visit. So I'm absolutely delighted and honored to be here. And I'm very grateful to Professor Lee, to Dr. Cheng, and to our hosts here at the Center for Bioethics for the invitation and for the opportunity to be here. So what I'm going to do today is hopefully not talk for too long, but I'll try and just address some of these issues about Professor Song's very rich and very, very interesting and intriguing talk. Sorry. I should stay nearer the microphone. So, okay. So it's a real pleasure to have the opportunity to respond to Professor Ji-Woo Song's lecture on climate change, health, and the right to a healthy environment. Professor Song's lecture takes, I think, really a very intriguing and promising approach to thinking about how philosophy can help us to think through the best form of response to the challenge of climate change. And in doing so, it, I think in a very interesting way, brings together issues from bioethics, from political philosophy, and from the philosophy of law in a very productive and, as Professor Song says, a very optimistic way, but I think it's quite incumbent on us to remain hopeful, and that optimism is really quite admirable. So, as we've seen, her approach is to develop the case for a third generation right, or a solidarity right to a healthy environment, which could form the basis to articulate claims against states to do more to respond to the urgent demands of the climate emergency. So I think there's no practical issue that could be more pressing or more significant. And we've got really strong reasons to welcome this kind of philosophical work that can try to help us to find new routes towards adequate institutional responses to these deep difficulties that we all collectively face globally in addressing climate change. So the main thing I want to say is to welcome Professor Song's intervention as a timely and as an intellectually ambitious response to one of the most important issues that humanity must address. So in these remarks, I'll just sketch some considerations to which she might want to respond in developing that account further. Okay, so here's Professor Song's diagram without the elegant purple center. So this was a sort of draft version of it, but just to remind you of the core of Professor Song's view. So on the account that Professor Song develops, which is grounded in the approach to human rights that we find in theorists like Henry Shue and Charles Bates and Thomas Scanlon, a human right is, and will I press the right bit of the, no, I don't know, how do I get the red? The big, yes, good. Human right. It's an institutional protection of urgent human interests against certain predictable dangers. Sorry, I should be doing this on the circle, shouldn't I? Or standard threats that are matters of international concern. Now, Professor Song illustrates this model of human rights with the aforementioned helpful diagram of concentric circles. As she puts it, there are then 4 components to this account, each serving to narrow and specify the content of human rights. Now, on the model that Professor Song develops, I think there can be no objection at all that with regard to the needs of human beings for a healthy environment conducive to their living flourishing or even adequately well-functioning lives, there are, of course, urgent general interests at stake and predictable dangers in the world from which people should reasonably seek protection. So I have no quarrel at all with the outer rings of the concentric circles. I think that's uncontroversial. But I think more could be said, though, about these inner circles of the diagram, and in particular as to whether the development of human right to a healthy environment would generate feasibly effective forms of international concern, and perhaps most pressingly, feasibly effective forms of institutional protections in the most pressing cases. So here really I'm just going to press Professor Song a little bit on some of the difficulties that she's already mentioned in her lecture, but on which more could be said. So consider two different ways of thinking about the enforceability of a human right. So we'll start with this nice straightforward case of direct feasible enforceability. So here, a human right to a healthy environment might form the basis, let's say, for me as an individual, a citizen in a particular country, to have a claim against the state in which I'm resident to guarantee access to particular goods. So here, the appeal to such a right might stand behind, for example, a claim against a government to provide clean air or safe drinking water. And you could think here of restrictions on car use that have been imposed in many large cities in different parts of the world, and how a demand for such restrictions could be justified. So if anyone here goes to London, you'll see these signs up all over central London, sort of marking out a zone of congestion charging in the center of the city. So there you could think about that being something where citizens could have a direct right against their home state that would justify that kind of policy intervention. So here there could be no doubt that a right to a healthy environment could be feasibly effective. But things get more difficult, as Professor Song herself has emphasized in her lecture, when we think about her central case, the case of climate change more broadly. So given that the causes of environmental degradation cross international boundaries, there might be only very limited institutional scope for a rights holder to demand protection of their right within the country where they're resident. So if my city were to become unlivable because of extreme heat, then my life would, of course, be adversely impacted by the loss of a healthy environment. But if the causes of that heat are the carbon emissions of distant polluters in other parts of the world, there's a concern that my right could lack enforceability due to a lack of a feasibly effective mechanism for its application. Now, Professor Song is, of course, aware of this difficulty and points out that not all human rights need to be enforceable against citizens' home countries. Instead, we can think of a human right as generating obligations of international cooperation that would lead to their progressive realization over time. Therefore, a different way of thinking about such a right would give us this sort of second model, a model of progressive realization through international cooperation. A human right to a healthy environment, for example, here may help to provide a justification for international cooperation that would itself generate that progressive realization of climate goals through, for example, alignment with international climate treaties. But what I really want to note here is there's a really large gap between these two ways of thinking about the function of a human right. The distinctiveness of using the language of human rights in case A, in that first kind of case, aligns with the way that the right might function as the basis for a direct claim against a particular state. So here, the human right to a healthy environment could justify claims for specific, narrowly targeted forms of environmental regulation. But in Professor Song's core case of climate change, the role of this human right has to become more diffuse, more aspirational, more optimistic in her own terms. We still meet some standard for the feasible institutional expression of that human right, but it's of a kind that has to be much weaker than in the case of direct feasible enforceability that you get in in case A. So in my remaining time, I just want to point to two aspects of that second, weaker form of institutional realization of the human right to a healthy environment. And first of all, I want to talk a little bit about issues of determinacy before... One thing about needing different glasses, I'm being told something about my time there, and of course I can't read it. Wonderful. One day I'll get some variable lenses. Good. So I will turn first of all to questions of determinacy before turning to some questions about background philosophical framing. Okay. So when we consider this weaker form, this second form of institutional feasibility, this idea of progressive realization through international cooperation, Professor Song pointed out that in recent rights-based climate litigation, how things work is that there's generally an appeal to the content of existing agreements, such as the Paris Climate Agreement. Now, in one way, of course, that offers a really welcome way of making the implication of a human right to a healthy environment more precise. The idea being that states' obligations with respect to that human right could be specified in terms of their explicit existing obligations under relevant international treaties. But what I really want to flag here is that this generates a problem of determinacy, which, if pushed, could come close to a problem of justificatory circularity. So institutional agreements such as the Paris Climate Agreement are, of course, in reality, an outcome of a process of bargaining in which stronger states were able to make use of their powerful position so as to avoid certain binding commitments. It's not implausible to think that obligations under the Paris Agreement didn't track the underlying normative considerations that were in play, either with regard to historical responsibility for climate change or with regard to plausible substantive accounts of what richer states owed to poorer states in terms of mitigation of climate change or adaptation to its environmental consequences. If a climate agreement is an imperfect consequence of bargaining and realpolitik, then we may have reason to be concerned if it's then treated as a normatively significant baseline for or normatively authoritative baseline, let's say, for judging whether states are meeting their human rights obligations. And here, I think, a really strong example is the case of Kiribati. So, given that the rise in sea levels is going to lag behind the rise in global temperatures, it's highly likely that Kiribati will cease to be a habitable environment in the near future. This is a low-lying Pacific island at the forefront of the effects of climate change. Now, that would still be the case even if all states had met their existing obligations under climate treaties. This would leave us in the strange position of thinking that for the citizens of Kiribati, their human right to a healthy environment does not or might not generate any clear obligations for action on others, even though those citizens are losing their access to a healthy environment in which they can lead their lives in the country of which they're citizens. So we see here the problems of determinacy that are involved in that progressive realization approach, in that sort of weaker version of the requirements of solidarity rights, such as the right to a healthy environment. If the human right is going to apply, then we need more of a sense of what is actually owed, for example, to the people of Kiribati in virtue of their having that right, especially under the difficult circumstances whereby even if states were doing everything that was demanded of them under the Paris Agreement, it's still not the case that that would guarantee a safe and healthy environment for the people of Kiribati. Okay, what I'm actually going to do, because these remarks probably took me a little bit longer than I expected, I'm going to draw a line here and we can move on to Professor Stanzik, and I'll just raise, perhaps for discussion in Q&A, or for Professor Song's further thinking, how we should think about the relationship between the tool that is our use of the concepts of human rights and then the underlying normative considerations about obligations of international and intergenerational justice and about ideas of the common good that might stand behind that. So thank you very much for listening.
Thank you, Professor O'Neill. We will turn to our third commentator, Professor Lucas Stanzik, who is joining us today via Zoom. Professor Stanzik, the floor is yours.
Hello, everyone. Can you see my slides okay?
Yes.
Great. So I'm sorry I can't be with you in person, but it's a pleasure to be able to participate nonetheless. Thank you to the organizers for making it possible. Let me start with 3 background facts. The climate has already changed dramatically because of humanity's use of fossil fuels. In many places, the altered environment has become significantly less hospitable to human health. And yet, even though these impacts are well understood, and even though the situation is only expected to get worse, at a global level, humanity's response to the threat of anthropogenic climate change has been very slow and very weak. In her lecture, Professor Song asks whether the recognition of in international law and practice of a human right to a healthy environment has the potential to contribute meaningfully to advancing the global response to climate change. And her answer is a cautious yes, stated in 2 parts. First, she argues that the idea of a human right to a healthy environment can be supported and defended philosophically against the most widely discussed objections to expansive human rights of this kind. Second, she argues that the existence of international treaties on other matters of international concern, as well as increasing codification of the human right to a healthy environment in existing national and regional laws, gives us reason to think that an international institutional response is feasible. I agree with Professor Song that there is a good case for recognizing a human right to a safe and healthy environment. And I think that her lecture presents an excellent approach to thinking about and defending this right in broad philosophical terms. So on this point, I'm just going to say that I'm in agreement with Professor Song on the big philosophical questions raised here regarding the idea of human rights and their role in international law and practice. However, I'm less certain whether the recognition of a human right to a healthy environment has the potential to meaningfully advance the global response to climate change specifically. And here my worry is not just the strategic worry that other efforts may be more fruitful, nor just the cynical worry that many powerful governments today, including my own, do not appear to care about human rights at all. Instead, the worry is that a focus on the human right to a healthy environment has the potential to obscure the most important moral truth about climate change, which is that climate change is not merely a matter of international concern, but above all, a problem of intergenerational injustice. Let me make this point in a few steps, making use of 3 distinctions. The distinction between climate change and destructive weather events, the distinction between slowing or halting climate change versus protecting people from its dangerous effects, and the distinction between international justice and intergenerational justice. On Professor Song's conception of human rights, which I endorse, human rights are institutional protections of urgent human interests against predictable dangers that arise in the global order as matters of international concern. Reflecting on the urgent interests that underlie the right to a healthy environment, Professor Song draws our attention to the environmental degradation caused by climate change and the way that a degraded environment systematically threatens human health. She has in mind not just extreme weather events such as severe heat waves, droughts, floods, and storms, all of which can seriously harm or kill people directly, but also the further knock-on consequences of such increasingly frequent events, ranging from destruction of infrastructure to crop failures and food shortages, to violent conflict over dwindling water resources, and eventually large-scale migration. But notice that there are two things at issue here, as Professor Song's phrase makes clear: dangerous environmental degradation caused by climate change. Moreover, these two things have different causes and therefore require different social responses to address. Climate change is caused primarily by burning fossil fuels, billions of tons of coal, oil, and gas. To stop climate change, humanity must stop burning fossil fuels, which means that humanity must transform the entire global energy system and countless agricultural and industrial processes in every country in the world. However, transforming the global energy system, even if this monumental task is accomplished, will not adequately address the dangers to human health inherent in an environment degraded by climate change, for the simple reason that the environment has already been degraded, and even more environmental damage is already locked in because of past climate change that no one can any longer do anything about. This means that there are two imperatives of responding to climate change and not just one. First, to prevent climate change from getting even worse in the distant future by phasing out all fossil fuels and radically reforming human land use. And second, to protect people from the dangerous consequences of already locked-in climate change by helping them to adapt to and survive these consequences. However, the challenge is that these two imperatives are increasingly in tension with one another in a way that directly bears on the human right to a healthy environment and its potential to serve as a basis for a global response to climate change. Let me give one example of this tension. In coming years, no matter what anyone does, there will be billions of people in India, Africa, Asia, and elsewhere who will face extreme and potentially deadly heat waves, but who do not yet have access to any kind of air conditioning. To protect these people from being exposed to deadly heat, the world will have to build a vast amount of additional electrical power generation capacity on top of the vast amount of renewable electricity that is already needed for existing purposes. And that will take a vast effort in terms of labor and materials such as copper. The world will also need to relocate millions of people from places that have become too dry to grow food. It will have to rebuild houses and infrastructure that will be destroyed in increasingly violent floods and storms. And all of that will require a great deal of scarce resources and labor power. Yet even as societies are forced to expend increasing amounts on protecting people from deadly heat waves and other kinds of extreme weather, humanity will continue to face the separate, immense task of transforming the global energy system in order to avert even worse climate change in the future. What's more, these two imperatives are in tension with one another and will increasingly compete for resources in the future. After all, the disasters from extreme weather will multiply from already locked-in climate change. Damaged roads, shelters, farms, clinics, and other infrastructure will need to be rebuilt. And yet the labor and materials expended on rebuilding all of this destroyed infrastructure will represent labor and materials that can't be deployed to accelerate the global energy transition by building replacements for diesel-powered ships and heavy machinery and airplanes and coal plants and domestic heating systems and so on. Let's call this growing trade-off, the growing trade-off between the imperative to avert even worse future climate change by rapidly phasing out fossil fuels, and the imperative to protect people from dangers to health posed by an environment that has already been altered significantly by climate change. I'm now in a position to make my main point, which is this. Reflecting on this trade-off helps us see a moral dimension of the climate crisis that a human rights approach can potentially obscure. This is the fact that the climate crisis is not only a matter of international concern, but centrally a matter of intergenerational injustice. That's because while the present generation benefits greatly from many of the activities that cause climate change, the very worst effects of climate change will not be felt by anyone until decades and even centuries into the future. To give just one example of this truth, there is now a real risk that the North Atlantic Ocean currents that make agriculture possible in Europe and which steer the African monsoon may pass a point of no return in the next few decades because of climate change to which our activities are now contributing. Crossing this point of no return would have truly catastrophic, irreversible effects on the habitable environment. Agriculture in Northern Europe and many parts of Africa would no longer be possible, among other catastrophic consequences. However, even after the point of no return is crossed, the ocean currents in question will take a century or longer to fully shut down. Therefore, no one who is alive today, and not even their children, will experience the worst long-run catastrophic effects of this event. The same is true for catastrophic sea level rise, which will eventually prove to be by far the worst effect of climate change, but many centuries from now. But now consider, if our focus is on the human right to a healthy environment as a matter of international concern, this may lead us to focus on threats to health that people alive today already face, or will soon face from an environment significantly altered by climate change. In terms of the trade-off that I described, it may lead us to focus on tasks like providing people with access to air conditioning so they can survive deadly heat waves, taking steps to share dwindling water resources, and helping people migrate away from places that have become too dry to grow food or that have experienced sea level rise already. These are, of course, very important and urgent tasks, and it would be a good thing if we could say, as Professor Song wants to say, that their importance is partly explained by the fact that there is a human right to a healthy environment. However, these protective measures, protecting people from deadly heat waves, rebuilding destroyed infrastructure, sharing scarce resources, facilitating migration away from inhospitable places to more hospitable ones. All of these tasks are not merely separate from the task of phasing out all fossil fuels around the world. In addition, as the disasters multiply, these kinds of protective measures are also increasingly in tension with, because in competition for resources with, the steps needed to accelerate the global energy transition and thereby to avert the very worst effects of climate change in the much more distant future. My overall point then is this: any approach to climate change that is focused on the human right to a healthy environment as a means of advancing the global response to climate change must somehow find a way to acknowledge and remain cognizant of a crucial fact. The climate crisis is above all a matter of intergenerational injustice, and the measures needed to protect an environment hospitable to human health in any given generation, including our own generation, are not the same as, and indeed in many ways compete with, the steps that will need to be taken to eliminate fossil fuel use globally and thereby prevent the very worst effects of climate change in the much more distant future. So I'll stop here. Thank you very much.
Thank you, Professor Stanzik, and thank to all the four commentators for their thoughtful reflection. May I now invite Professor Song to the stage to offer her response? Professor Song, please.
Okay, I'll just try to be as concise as I can. So I'm grateful to my distinguished discussants for taking the time so thoughtfully to engage with my arguments. I'll take the comments in turn, though there are clear overlaps in theme and concern, which I hope to note. I'm glad that Professor Chung has gone into so many of the details of fleshing out how the human right to a healthy environment might be realized. I agree with all his points about progressive realization, distinction between rights and outcomes, the tripartite typology, the idea of minimum core obligations. These are all parts of human rights doctrine with respect to socioeconomic rights that are measures to guard against states just being like, oh yeah, we're getting there. Of course, we think these rights are important. We're progressively getting there, not doing anything. So these are all sort of measures to impose rigor on the implementation of human rights. And I think it's important that we keep them in mind if we were to institutionalize the right to a healthy environment in international law, as I argue that we should. I also appreciate Professor Chung's careful discussion of statism. So one problem that often happens in the global justice debate is that people are driven to extremes. Either there are no duties of justice outside the state, or we need a world state. So arguments like the one that Professor Chung provides show us that there are more nuanced avenues towards establishing more robust duties of justice that go beyond state borders, and I am fully on board with that. Finally, the point about implementation challenges, it's well taken. I think this point meshes well with the comments that I ended my talk with. Also to a point that I mentioned earlier in my lecture, where I discussed how this recent burst in climate litigation is partly a result of there being political blockages in getting more robust action on the climate emergency, because there are, say, climate skeptical political parties that are in power. Now, one worry that is thrown into relief by Professor Chung's remarks is that even if we get victories in court, if implementation requires resources that would have to go through the political channels anyway, get budget approvals, for instance, then we might end up where we started. So this is a serious challenge, and it is something that I think requires and would demand quite rigorous, careful empirical investigation as to whether, and this is an important part of answering the question, is this strategically a good idea to pursue rights-based climate litigation, right? So thanks so much for those comments that really contextualize and enrich my rather threadbare arguments. So Professors O'Neill and Stanzik believe that we're dealing here with more than strategic worries, that there are deeper philosophical worries. Professor O'Neill worries first about feasibility, that there's a potentially large gap between what he calls direct feasible enforcement, which is just demands that you make against your government, better regulations, less pollution, things like that. And what he calls progressive realization through international cooperation. So say an ideal implementation of the Paris Agreement. So what a framework like the Paris Agreement does, I think, is help us go some way toward closing this gap. So when individuals bring rights-based climate litigation cases, a very common form of this claim is that their government is failing to meet its pledges under the Paris Agreement. So a framework like the Paris Agreement allocates cooperation burdens on each state party, right? So here are the individual state parties to the agreement, and their citizens are able to make direct claims for their governments to follow through with their pledges under this framework of burden allocation, right? So this translates the second model of feasibility, progressive realization through international cooperation, into a form that omits of direct claims against governments. There is, of course, the complication that maybe the claim you want to bring is not against your own government, but against other governments that seem to be more heavy emitters. And on this, this is a point, again, about law, so I won't go into too much detail. The jurisprudence is currently in flux. There are some courts that say, no, we're not going to allow for that kind of extraterritorial claim. There are other courts, incidentally, the Inter-American Court of Human Rights tends to be the most progressive on these issues, is moving in the direction that says, yeah, if what you're doing in your country has effects elsewhere, that creates jurisdictional links for direct claims against you. So, and all of that, I think, is made possible by the fact that there's this framework of international cooperation that allocates cooperation burdens on individual states. Now, to be sure, the Paris Agreement is ridden with many problems. It's the result of piling compromise upon compromise, right? And Professor O'Neill described some of the more serious ones, and none of what I said is meant to deny that there are these problems that exist. All I want to emphasize in my moment of optimism is that there is this framework that allows for a closing of the gap between the two kinds of feasibility that Professor O'Neill mentions. The slide that Professor O'Neill ended with but didn't get to discuss in much detail is about how perhaps human rights are not the most demanding sort of standard of justice what we might push for, that they're rather moderate in what their aims are. And it would be a mistake to think that they're all there is to the justice of climate change or to climate justice. I completely agree with that. I didn't mean for my paper to be suggesting that this is the end all be all of climate justice. I do see how these worries might arise, given that I'm focusing on rights-based climate litigation and the human right to a healthy environment. Just by way of background, this isn't a philosophical argument, but it may be interesting as a point to make clear where I'm coming from. I focus on this issue because it's where a lot of the action on the ground is. It's where it's what a lot of climate advocates seem to be doing these days, latching on to human rights arguments to urge more robust action on climate change. And this, again, raises empirical questions. Is strategically a good idea? My own sort of default inclination, not sort of a rigorous social scientific position, but my inclination is to have some measure of faith in what practitioners and advocates on the ground are doing, given that it's their job. They probably have been assessing all the different avenues that are available, all the different actionable courses that are available to them, and think that this is something that can be done now. But of course, in the long run, we may all be collectively mistaken. So that is a worry that we need to keep in mind. And I, in my other work on human rights, I argue here and there that human rights are only a part of the whole picture of global justice. I think it's very important to keep that in mind, as Professor O'Neill urges us to do. I do think that there's a deeper disagreement between my view, or more precisely, the unspoken parts of my view, and Professor Stanczyk's central claim that international human rights may be an ill-fitting tool for climate change response because the climate emergency is a problem of intergenerational justice. I feel like the strength of this claim depends crucially on thinking that perhaps the fact that human rights are focused on international concern somehow makes it more difficult for a human rights lens to also focus on matters of intergenerational concern. It's not clear to me why that should be the case, any more than it being the case that accounts of domestic distributive justice may have difficulty folding in considerations of intergenerational concern just because of the way that they're set up. Now, intergenerational justice is, in general, a difficult and under-theorized philosophical topic. For example, because there are all these questions that we have to decide on. So how to assess and evaluate the interests, claims, and rights of people who do not now exist is a problem that creates lots of philosophical puzzles. There's a whole literature, a whole field of literature and philosophy on this, and the issues are too complicated for us to fully resolve here. It's not fully resolved in the literature. I should note also that in the litigation cases that I've discussed, court decisions have tended to settle for philosophically uninteresting resolution to these questions. For example, by extending the concept of future generations to include people who are very young right now, right? So babies and infants. So thus eliminating the problem of non-existence, right? As Professor Stanzik rightly notes, this will do little to help us think through and anticipate the catastrophic effects of climate change that will happen centuries from now, right? When the people who are affected are clearly people who don't exist at the moment. I don't think, though, that these problems are especially significant for a rights-based approach to climate change. These are difficult problems more generally for any approach to the challenge of climate change. And the way that Professor Stanzik set this challenge up as a sort of contest between mitigation and adaptation illustrates the sort of generality of this problem. So mitigation and adaptation, as those of you who study climate change will know, are supposed to be the two main pillars of climate change response. It's what the scientists say we need to do. It's what the social scientists say we need to do. It's what the philosophers say we need to do. And it has long been recognized that there's a potential tension here. And it's very well illustrated through the example of air conditioning. You may recall that I used a graph on air conditioning that shows that low HDI countries just have very low percentages of households with air conditioning. So adaptation would involve perhaps providing more air conditioning in those areas. Mitigation would be the mitigation pillar would be very worried about that, about increasing the use of AC around the world, because that would contribute to climate change in the long run. So these are admittedly difficult problems. It's not clear to me why we should think that this is more of a problem for a human rights approach to climate change, because if anything, it seems to me that the individualized focus of human rights, which allows us to zoom in to the plights of vulnerable individuals, might be an advantage of the human rights approach when thinking about intergenerational justice. So here I'm going to draw on some of the arguments that the philosopher Henry Shue has made. So Henry Shue is a very influential human rights theorist. He was the person who originated the tripartite typology of human rights duties that Professor Chung described. His more recent work has been on climate justice. And one of his arguments has been that we need to mobilize the logic of human rights in order to think about the claims of future generations who don't now exist. Why is this useful? Because human rights have this kind of inner logic that allows us to pay attention to the potential claims of people who are especially vulnerable. And future generations are people who are especially vulnerable. So this is a quote from Shue's book, Climate Justice. A situation in which some humans are utterly at the mercy of other humans, but those others have the capacity to create institutions to protect the vulnerable against the forces against which they cannot themselves protect. They cannot protect themselves is the paradigmatic situation calling for the recognition and institutionalization of rights. So on this logic, future generations are people who are utterly at the mercy of current generations, persons who have the capacity to build institutions to protect them. So this means that future generations are sort of naturally folded into the logic of human rights. This does leave us with the question, what about the vulnerable people who exist now, right? So there's this tension, there's a shortage of resources problem. That's a difficult problem. I'm not trying to deny that it's a difficult problem. All I'm arguing is that it's a difficult problem that any approach to climate change will have to face. In the process of thinking about the trade-off, I think, just to highlight a point that perhaps didn't come out as forcefully in Professor Stanzik's comments, we should also think about the potential resources that would become available if the more affluent of us, say, were to resist perhaps using AC as strongly as we do. I remember in graduate school, there was a building called the William James Hall building. It was a psychology building. I remember friends in the psychology program would get so cold during the summer months because the air conditioning was so strong that they would have to come out, say, at 3 p.m., the middle of August, to warm themselves on the stone bench in front of the building, right? So that's perhaps an example of an area where we could sort of differently allocate resources to help with this trade-off. Not saying that that's going to solve the trade. The trade-off is a very serious one. It's one that we need to tackle. All I'm saying is that it's not particular to the human rights approach that I've been sketching today. Maybe I should stop there. Thank you.
Thank you very much, Professor Song, for your insightful response. So please join me in giving all the speakers today a warm round of applause. Thank you very much. So we will now move on to the Q&A session. We would like to open the floors for questions and reflections from our audience. This will be a valuable opportunity for further dialogue and for exchange of ideas. So we also welcome comments and questions from our online audience. Okay. So may I first invite Professor Song, Professor Chong, and Professor O'Neill to take their seats on the stage. May I now invite Professor Amos Tai to come to the stage to moderate the discussion. Professor Tai, please.
Right. Thank you very much, Professor Song, for a very fascinating and insightful lecture, and also for the very thoughtful reflections from all of the commentators. So as a climate scientist myself, I was particularly struck by how your discussion of all of these justice and rights really resonates with the inequities that climate impacts are really bringing forth to the world right now. For instance, how climate-driven disruptions to food security and public health really disproportionately affect poor nations and vulnerable communities. These are issues that even my own research kind of try to unpack from the scientific perspective, and it's inspiring to see them examined through the lens of rights, bioethics, international, and also intergenerational justice. So now it's really the floor open for questions and answers right now, and more discussion. So we have about 10 minutes to do so. So please raise your hand if you'd like to ask questions. And also when the microphone reaches you, you can state your name and affiliation as well. And also keep your question concise so that we can take more within the time we have. All right. So now is the floor for any questions? Yes, please. Derek.
Yes, my question has to do with the standard which you hold the government for the duty or failing the duty. Professor Chung mentioned the idea of adequate protection not being maximum protection. And you also mentioned the Paris Agreement. But I was wondering, even with that Paris Agreement, it would be subject to debate on how poorly the government must have performed to be considered inadequate in terms of violating the human rights. What's your thinking on that? How badly does the government have to be doing before you can say that you are not doing the minimum to adequately protect the human right?
Yeah, anyone can take the stage to answer. Yeah.
Okay. Well, I think it's a. Hello. Hi. I think it's a very good question, and there's a lot of philosophical debate about adequacy, right? Adequacy according to whom? How are we going to draw the line? I mean, if you look at adequacy in terms of healthcare policy over here in Hong Kong, the overarching policy of healthcare in Hong Kong is that no one should be denied adequate healthcare due to lack of financial means. But if you push this a little bit further, that what they're really saying over here is that there's got to be a basic minimum. So one of the approaches that I have talked about, it's at least there's at least a minimum core approach to this. So I think that's a very good question, but there is different approaches to this. Some people would say probably we need to have consensus. Okay, we need to have empirical consensus study as to what it means. And I would also believe that it is highly contextualized. It depends on where you live, you know, which jurisdiction you're in, and et cetera. But are there any other comments on this? Thank you.
Just to add a point in agreement, adequate is one of these words that in legal norms are often used deliberately to allow for some degree of flexibility, right? So adequate, insufficient, sufficient, these are words that often signal flexibility or seen in a more negative light, indeterminacy. A lot of countries where the judiciary is active in creating jurisprudence come up with more specific principles to flesh out or specify the notion of terms like adequate. In the Korean constitutional case that I mentioned earlier, what happened was that the Korean climate laws had fairly more specific mitigation goals set to 2030, I think. And then for the mid to long-term period, left the goals really open. And there was no commitment as to how much the government would do during that period. And it was really sort of backlogging the burdens to later periods. The Constitutional Court has a principle that prohibits insufficient protection of rights. That's the term. So this insufficient is another kind of flexibility term, and ruled that, yeah, this really goes below. The plaintiffs wanted the short-term goals to be also ruled inadequate. But the court said, well, the short-term goals, they're trying to do something there. But with the long term, there's no content as to what the government's going to do. That's really inadequate. So you kind of have these cases that sort of build up to flesh out and specify within a jurisdiction what adequacy will amount to. And I think that's how the law usually would have to work.
Yes, please.
Thank you. I have two quick questions. I mean, the first one is that it struck me that Professor Stanzik's point about intergenerational justice, I think that is relevant to Professor Song's idea for these reasons. Suppose someone in India is complaining of the heat waves, right? And that result, the heat wave, might have been due to something that has happened a long time ago. 80 years ago, 150 years ago. It's not implausible to make that claim because of the accumulative nature of destruction to the environment. So, and the reason why I think that is relevant to your approach is you're talking about human right, legal right, and one thing about the court, the International Court of Justice. And if you bring a legal action against someone, that someone might have not existed already. I mean, that country might have since been under the water, or the regime has changed, right? And so forth and so on. So that is the first question. So because insofar as we take into account the accumulative nature of the destruction, we're not talking about a synchronic, but really back to the past history. And the second point I want to make, and I'm sure is not really an original point. I'm sure someone must have made a similar point before, and that is, what if the human rights conflict, for example, the human right to a healthy environment conflict with the human right to a basic income? Okay, for people, I don't know, maybe a Trump or Trumpian might say, oh, in order to give everyone a basic income, we must use more fossil fuel. I'm just wondering how to resolve that kind of issue. Is it, do we look back onto the consequences and utility and so on, or what?
Okay. So I think one thing that the discussion between Professor Song and Professor Stanzik really brought up is something that you touched on there in your question, which is just the fundamental question that feels like it's sort of slightly standing behind a lot of the discussion here, which is how we might think that a human rights framework could or could not cope with intergenerational issues. As Professor Song was saying, there's one way of thinking about this, kind of making use of an idea from Henry Shue, that the human rights approach looks tailor-made. If one thinks about who could possibly be more vulnerable than sort of future people who aren't able to kind of defend their own claims. On the other hand, given weighty philosophical worries from Derek Parfit, worries about the non-identity problem and so on, that there might be a different way of thinking, that actually a human rights approach is sort of in really kind of in tension with that other way of thinking. On the issue about the conflict of rights here, I think part of why I'm a little bit worried about the human rights approach is that what that often does is pushes us towards thinking that the issue is one about kind of piecemeal claims that individuals can make with regard to small changes that are needed, where we leave everything else as it is. Whereas it seems like the problems of the climate emergency are so fundamental. They're about the pathway of future investment. They're about decisions about the long run directions of our societies that don't really look like they're that well captured by that framing of sort of making kind of smaller piecemeal claims against our states. So I think, if we think, for example, about the tensions that might exist between dealing with climate change and then also worrying about having enough economic activity to make sure that people have got an income, that points towards the fact that actually that there are such deep structural issues of social and economic policy at play that's one way in which I worry that the tool of human rights, although no doubt very useful in a lot of circumstances, might have the effects in some cases of redirecting our attention away from some underlying structural questions about the long run social and economic policies that our societies pursue. So that's a very general and unhelpful answer to a very good question. Thanks.
Just to add to that last point, though, I do think that's a really important concern generally. So in countries where the right to health is a constitutional right, one problem that's emerged is you get all these cases where middle-class plaintiffs bring constitutional court cases for access to fairly expensive medicine, which has the effect that, people who are worse off are left even worse off because of the resources used in that way. What I do find more encouraging about climate litigation is that often these cases are impact litigation cases, and the demand is not so much for adaptation, but for mitigation, right? So you have, I think, cases that are part of a larger, broader sort of project of making more progress on mitigation, which feeds into the intergenerational justice point as well. But I wonder if, do you have time to hear?
Yeah, exactly. So yeah, I'm exactly about to ask, since this is about intergenerational problems, does Professor Stancic, do you have any comments on the questions?
I'll just say very briefly that I share some of the worries that Professor O'Neill just mentioned, but I'm also quite interested with Professor Song in seeing where the climate litigation will go. And so I'm particularly interested in the form of the claims, because as Professor Lee just mentioned, one way in which you can express the claims is as a justiciable claim for a harm that has occurred to me, now is occurring to me, or occurred to me in the past. And that will focus on us on the dangerous and destructive effects of already locked in climate change, and redirect us away from questions of transforming the global energy system and mitigating emissions and questions of the distant future. But perhaps there are ways to formulate claims in courts before human rights tribunals or before constitutional courts that do, perhaps they will require alternative formulations of maybe long-lived institutional agents or groups who expect to be around a long time and a series of generations who say, no, you must take action to preserve a sustainable environment for the indefinite future and formulate the content of a right to a healthy environment that way.
So I myself have a very burning question that's very much related. So, I pay a lot of attention to these climate litigations cases, and then I often would pay attention to the scientific robustness for the grounds where these sort of litigation is based on. So my question is really about predictable dangers from the perspective of, so of course, climate science. We know that our model sort of capability to predict the future are improving over time, but definitely uncertainties still remain inevitably. So, and my question is, so how should scientific uncertainties, or conversely, the growing sort of robustness of climate evidence really shape the normative and legal grounds for institutional action? Or in other words, how does the ethical obligation to protect the human rights to a healthy environment already arise from plausible risk and precaution? Or does it have to reach a certain level threshold of confidence before we can to claim it as predictable in order for us to actually act on it?
I feel like this is a super important question for environmental cases generally that, as far as I understand, are not treated as super challenging for courts in climate cases. So what courts generally have been doing is just taking the IPCC reports and saying, look, it seems uncontroversial that we're in trouble and urgent action is needed. But the general form of the question seems like a very important puzzle for environmental cases generally. So if there's a right to a healthy environment, that would cover non-climate change cases as well. So that would be an important category of puzzles to address in designing litigation. And if I may just add to the point that Lucas made, the comments that Lucas just made make me think that these, I know this isn't going to satisfy Lucas, but Professor Stanzik, but from my perspective, a lot of these comments are super helpful in informing the design of rights-based climate litigation. So designing litigation cases so that they serve the broader project of mitigation, global mitigation, that would help with whatever harmful effects are not already locked in so that we're all doomed. So that would be my takeaway. But of course, there are more issues there. Right?
Great, thank you. Any other questions from the audience? All right.
Oh, thanks. Since we mainly talk about climate change, but climate change may also worse environmental pollution like air pollution and water pollution, which significantly damage our public health. So how can we better integrate climate action and pollution control to improve our environmental quality via like human rights and political perspectives?
Could you just say the last bit again? I don't think I fully got it. Sorry.
Yeah. Because I'm from a scientific background, I'm a science student, so I really want to know how we better integrate climate action and the pollution control from like social science perspective, mainly from like political perspective like this.
So as we were just saying, a human right to a healthy environment would cover not only the harmful effects of climate change, but also environmental degradation generally, which might include things like general air pollution, water pollution. Admittedly, a lot of current air pollution is related to climate change, but there may be unrelated cases as well. Building on something that Professor Chung said earlier, there's a certain understanding of the right to a healthy environment that is suggested by a recent opinion by the Inter-American Court of Human Rights that suggests that there's this right to a healthy environment, and then there's a core within it. This is a right to a healthy climate, right? So that, because climate change is such an existential threat to all of us, that would be sort of something like the minimum core. And then these other cases, say non-climate related air pollution cases, would fit into the rest of the obligations associated with the right to healthy environment. So that's one way to flesh out the relation. But that's a really great question.
Right. So I think time is almost up, and we really thank all of you for very, very engaging questions.
I have a question for you, Amos. I mean, as a climate scientist, what's your takeaway from this conversation today?
I mean, I myself often emphasize climate change as an issue that is not only about, polar bears or even ecology, but it's really about human being and rights and justice. Yeah, so I'm very, very fascinated by the discussion here. And I often think about, yes, from a scientific perspective, for instance, for someone in Pacific Island, living there, trying to make a case for, international cooperation, it's actually very, very hard still to sort of attribute the exact sort of a demise that they're facing to a specific actions. I mean, a specific players. So that's why I'm talking about, like evidence. How much evidence do we need to do the attribution so that we can say, okay, you are responsible and you are responsible, and let's do something about it. But right now, I think the connections are still a little bit flimsy right now to really make that very strong international claim. But I think international speaking, it is very important framework to establish.
Thank you.
All right. Well, thank you very much for everybody. And this discussion, really show how interconnected science, ethics, policy, and law and philosophy are. And I would like to pass this time back to Roger.
Okay. All right. So I would like to close the. Oh, okay. Oh, okay. There's some slides too. Okay. So thank you, Professor Tai, for the navigating the dynamic discussion today and the Q&A, chairing the Q&A. Please give a big hand to Professor Tai. And thank you everyone in the audience for the participation today. So we bring the 8th Lanson lecture to close, but I would like to just want you guys to pay attention that there is a follow-up to this conversation. It's more of a seminar on justice, states, and markets in the time of climate emergency that is going to happen on Monday. If you haven't signed up, but if you're interested in this topic, please sign up. This will happen next Monday at 3 to 4:30 at the BMSB at the main campus. So I hugely look forward to this conversation, and probably some of the things that we have talked about today will carry on. Do you have anything to say about this?
Just that it's also an opportunity for the tables to turn as Professor Song will turn commentator and can tell you what's wrong with my approach to these things. So I'm very much looking forward to that. And I hope some of you can join us as well.
Thank you. Thank you. And as the co-director for the Center for Bioethics, I would like to send my deepest thanks to our distinguished speakers, Professor Song, for a wonderful, wonderful, and very provocative lecture on a right to a healthy environment, and also to our two discussants today, Professor O'Neill and also Professor Stanzik, who is probably still online, for the pressure testing, and also for the very constructive feedback to today's conversation. And there are other things that we're looking forward to. So coming up next in May, we're going to have another event that we will speak to the public directly about the advanced decision on life-sustaining treatment ordinance, which is going to come into effect by May or in June this year. So we will have conversations about how we should understand the law in practice, what we're going to do, how do we understand mental capacity, and also the relationship with advanced care planning. So this is very, very practical about end-of-life care. This is going to come up next. So please pay attention to our LinkedIn and our social media for registration later on. And then we're also going to fly over to Johannesburg and also Paris in June and also in July for more conversation about global bioethics and also AI and moral education using AI. So please follow us. And thank you very much, everyone, for a wonderful, wonderful morning of meaningful conversation. Thank you very much. Thank you.